I think the last speaker of the day for this particular session, our friend from Karnataka, Dr. SHRINIVAS JOSHI, who will be speaking about landmark judgments. And those are very important judgments in the field of medicine, in the field of ophthalmology. Definitely those will be useful for all of us to study those cases and take proper precautions and how to handle those things.
My elder brother, Dr. Viral Shah, and all the respected faculty here, Dr. Rajesh sir, Dr. Marathe sir, and Dr. Anil sir, for giving me this opportunity. Actually, this was a difficult case for me to do that. The landmark judgments related to ophthalmology, I think Dr. Viral Dada had given me a real tough job to do that. I would like to acknowledge Dr. Rishikesh and my nephew, Mr. Srinidhi Satyamurthy is now in Mumbai for this. So, Court of Record is a perpetual memory and it's a testimony. The judgments, proceedings and acts of the Supreme Courts are recorded for perpetual memory and testimony. So I think, I don't know if this has been discussed, but let me little bit rebrush it. Whenever a complaint is received against a doctor or a hospital by the consumer forum or by the criminal court, before issuing the notice to the doctor, the court should first enter the matter to the competent doctor or the committee of doctors. Only after that, the doctor or the committee reports that there is a prima facie evidence of negligence. But the shift has happened recently, not required to have such an expert opinion in civil matters, but still the court can ask for an opinion in Consumer Protection Act case. Now it is totally at the discretion of the court and not a hard and the fast guideline. So section 304A IPC, negligence causing by death any rash or negligent act, it is necessary to prove beyond reasonable doubt the degree of gross negligent act. In fact, section 88 and 92 of IPC are actually favoring, because section 88 act not intended to cause death. So that is done in the good consent, in good faith for the person's benefit. In section 92 IPC, the act done in good faith for a benefit of a person without the consent, especially when it's an emergency case, or if there is nobody along with him and he has met with an accident or any of those cases, then it can be taken without consent. So that is itself approved by the laws. Although it is a cognizable offence which the FIR on table deaths, especially when we are operating on anesthesia, general anesthesia, it might be booked under 304A. Though it's a cognizable offence, but under judgment it is treated as a bailable offence, and doctors should not be arrested under section 304A unless the opinion is taken from an expert doctor or the committee of doctors expert in that above said field. So, for negligence to amount to an offence, the elements of mens rea, means guilty mind, criminal intent, must be shown to exist. Otherwise, simply they cannot arrest a doctor, or they cannot just charge it on the court. And a doctor cannot be treated as a criminal at first instance unless the examination of the facts and the circumstance of negligence in the case prima facie reveals very gross negligence. So I have quoted all the cases also above of the slides for the references. Here came the CPA, that is the Consumer Protection Act, because the Supreme Court of India, the IMA lost the case in the Supreme Court of India, where they thought that the service rendered to a patient by the medical practitioner by the consultation, diagnosis or treatment, both medical and surgical, would fall within the ambit of service. In fact, IMA argued that medical profession is a noblest profession. It is not like banking services, internet services, or any of those kind of services. So it should not be included under the CPA. But IMA lost this case, and the Supreme Court ordered that this has to come under the ambit of Consumer Protection Act. So where the services are totally free to all patients, the government servant who receives service under CGHS scheme or railway is not considered as a consumer. So hence the cases cannot go to CPA. Whereas the services, when the services are paid services to all the patients, then definitely the staff of these hospitals comes under this vicarious liability of CPA. Even the free patients, the charity patients also, if we do, and if they go for a complaint in the court, that also comes under CPA. Why? Because somebody else has paid for that charity. It's not that free it has come. Somebody else has paid the money for that patient. So the money is exchanged. So that also comes under the CPA. So again, which protects the doctor? The nucleus drop occurs if removal is not feasible and it's not possible to determine the exact power of the IOL. If the IOL dislocation takes place or if the patient does not follow the instructions of the doctor, then definitely these are actually the protecting points because these are already listed in the textbooks. The criteria for the doctor is no sort of negligence that took place in the OT has to be proved. How much to charge? It is definitely the charge of the medical service. Doctor is not entitled to approach the consumer forum for recovery of professional service. Fees paid for operation also includes under the post-acute. So let's look into a few of these cases. Dr. X versus Dr. Z. It happened in Andhra Pradesh in 2013. The complainant suffered a PCR with a nucleus drop at the time of cataract surgery. There was delay in the second surgery of removing the lens drops and putting a secondary IOL because the patient was having uncontrolled diabetes and also a case of ARMD. The opposite party submitted extract of the textbook, and under the head, the other complication, it is mentioned that posterior capsular rent with vitreous loss is one of the complications of cataract surgery. So is nucleus drop through the rent. So with this, there was no chance for the second doctor, who actually was a complainant, to prove that the first doctor did absolutely wrong and he did not have any evidence for that. So it was not held in the court of law. Now this is another Amulak Ray versus the Dr. X. Again, 17th October, the patient underwent IOL implantation. The post-operative refraction showed plus 17 diopters. Now the most of the investigation relating to the selection of the lens were done by the sophisticated machines. You have to show that. You have to show that the machine was working well, the machine maintenance was doing well, everything was going well. The patient underwent the IOL exchange at another institute, after which he filed a lawsuit. But here, because the machine maintenance and records for everything was shown, the doctor was not proved guilty because it was the error of the machine and not of the doctor. XXS Hospital, Avinash Kumar, 2014. After cataract surgery, dislocation of the same was noted by another specialist who explanted the lens and implanted an SFIOL and also performed ILM peeling in the same sitting. This was not noted by the first operating surgeon due to high grade of cataract and the preoperative and due to postoperative corneal edema, which was managed by the same doctor. But the patient did not follow up because he has to see the post-op fundus, whether there is ERM or whatever, macular pucker or whatever it is there. And the consumer for concluded that IOL dislocation was a known complication of the surgery and that the patient was the contributor negligent in not following up properly. Hence, the court did not the further submitted that no expert opinion or document is required at all to prove the negligence in this case. So this another case, the patient had a PSEG attack for which YAC PI was done, following which he developed CRVO and claimed that it's a medical negligence on the doctor because he did the laser and I lost vision. The court held that the doctor was not negligent as he was the best judge who at the spur of the moment tried to carry out the laser treatment instead of giving anti-glaucoma medication in order to ensure that there is no further damage to the retina. And the patient was explained regarding the YAC PI. Patient was deteriorated because of CRVO. The cause may be hypertension, but the patient did not take any treatment at that time. So the doctor was not punished. Now coming to last 1 minute about the ophthalmic camps. We talked too much about this ophthalmic camps, right? So it should not be an unsupervised training ground for the postgraduate. There should be a proper pathologist, physician and all medicine. Now look at this. Original jurisdiction, written petition, Supreme Court. Lions Club, Pottery Town, Khurja arranged an opened eye camp at Khurja after obtaining necessary permission from the Chief Medical Officer of Bulan Sahab. In this connection, the club invited Dr. X and team of doctors to do the surgical job. The problem here was the club propagated with the literature that get operated, go home. No restriction on food, no bed rest, no stitches, no that, no this. So 108 patients were operated, 84 patients developed endophthalmitis. The Supreme Court, after this, led the guidelines for how to operate in the camp surgeries. The fault was actually in the saline bottle procured by the government authorities, and the government was actually asked to compensate for each person. So this was again, it happened at a popular hospital in South India. The cataract surgery was performed to 66 patients. On that night, most of the patients started complaining all the signs of the endophthalmitis. 61 of them lost their vision and 5 partially lost in their operated eye. The Chief Judicial Magistrate which heard the case convicted Dr. X, that is Director of XXX Eye Hospital, Chief Medical Officer and Chief Administrative Officer under Section 338 for culpable negligence and endangering the personal liberty of the patients and voluntarily hurting them. The court also ordered the payment to all the victims from 2.2 to 5 up to 5.17 lakhs. So this is what happens when it's not in your hands, it's in the chain. So we have to prove that the vendor who gave us all these things and which happened through that, the faulty process, they have to be blamed. So the proper systems have to be in place for us to be secure. So doctor is not negligent if the reaction is not identified and managed in any time acute. So I think the lot of things are there. But lastly, I would like to say discharge cards is very, very important. Poor records, definitely a recipe for disaster. The State Commission held that there was negligence as per the case sheet did not contain a proper history with proper treatment investigation, and hence that doctor was sued in the court. And also instances are there that they gave a discharge summary, they unfortunately wrote the wrong date of the surgery. Everything goes fine if all goes well, but in case the patient develops a complication, the lawyers will pick up this point that it has been mentioned as a wrong date, and definitely the court will say that there is no proper documentation of records. So negligence of the doctor is defined as breach of responsibility or the duty, and just the treatment is as per the standard textbook accepted by professional practice, and still the patient suffers loss or injury, then the doctor will not be held responsible for this. Merely because a complication has occurred, that doesn't mean that the doctor is negligent. So as sir just now said, the medical man is not an insurer. He does not warrant successfulness of the treatment or cure of the patient, which is said by the judgment itself. So I think last I would like to say the government of Maharashtra has passed an ordinance where any act of violence against a Medicare service person or damage is punished with the imprisonment up to 3 years and fine up to 50,000. The offence shall be cognizable and non-bailable. In addition to the punishment, the offender shall be liable to the compensation to the pay. So I think this was done in act passed in 2010. I hope all the other states also do such a proper thing. So thank you very much for the patient listening. Thank you, Viral Dada, for this opportunity.
Thank you so much.